everyone, and welcome to the daily newspaper analysis, which is brought to you by LawSikho. So, today we have an editorial for our discussion that has been taken from the Indian Express. It talks about the recent pulling back of the data regulation bill that was under debate for a long time. Why was it pulled, and what new things will we be able to see in the new legislation are discussed over here? Then we have the news update and the legal news. So the government recently has withdrawn the Personal Data Protection Bill from Parliament after it has planned to bring forth a comprehensive legal framework to regulate the online space. So basically, they are saying that the new bill that we'll be talking about will have, a greater coverage of the things that we'll be requiring for regulating the online space, and that is why we have pulled back the earlier legislation. So the government has taken this step after nearly 4 years of the bill being debated over. We as the users of various kinds of online space, and also the stakeholders in this particular area, we had already been looking forward for this particular bill to come up and become a law. But now again, I think we will have to wait a little longer, because a new bill now will come forward and that will be debated upon. So let's hope that it comes as soon as possible. So the data protection law was being discussed from 2018. This was the question actually which I had asked yesterday, that which committee was it based upon? So there is a kind of confusion that I could see in your answers in the comment section. Actually, guys, I wanted to know that which committee is this bill based upon, as in, which committee suggested having this bill. So it was actually Justice Sri Krishna or Justice B.N. Sri Krishna committee upon which the Personal Data Protection Bill was based. And the Joint Committee of Parliament is also an important one over here. But this was the one, B.N. Krishna committee, that actually brought the drafting up of this bill. So when Justice B.N. Sri Krishna committee, it drew up a draft version of this bill in the backdrop of the Supreme Court judgment that held privacy as a fundamental right. Now here is a very important and rather very easy question for you all, that in which judgment did the Supreme Court hold that fundamental right, right to privacy is a fundamental right? For all the listeners who are there in today's newspaper analysis, please guys, pause this video right now and let me know the name of this particular case. Moving forward, the bill was reviewed by the Joint Committee of Parliament, which submitted its recommendations in November 2021. And in December 2021, this Joint Committee of Parliament tabled the bill in the Parliament, to which Justice Sri Krishna criticized it as an Orwellian state. Now, when we talk about the Orwellian state, it is kind of a description of any action, step, or anything that is done in a society that is against the idea of welfare or mass happiness. So this, it said that the very particulars that have been talked about in the bill, they are in the light of an Orwellian state, and that is why we should not be moving forward with this bill. So one of the primary issues that were faced was that instead of being a personal data bill, the same became a bill that was dealing with non-personal data as well, because we particularly wanted something that could help us out with the dealing of the personal data, and the name also was Personal Data Protection Bill. But if we've talked about the intricacies that were there in this bill, so it didn't even just talk about the personal data, but it also talked about or dealt with the non-personal data, which definitely could cause a lot of ambiguity. So the new legal framework that is being talked of cloud deal with data localization and to do away with the trusted hardware suggestions and storage of personal data within India. So definitely there are some, there were some issues that were there with the earlier bill, and we're really hoping that with the upcoming bill, we will cover up all these things and that it comes well within time. So the new bill could also do away with the classification of personal data from the standpoint of data localization that is based on the geographies, and thus we will not have a problem when we will be dealing with the international market, let's say maybe Google work in India, for example. Now let's see, what do we have for news updates today? Firstly, ICMR starts new initiative in the Northeast. So the Indian Council of Medical Research has inaugurated the Foodborne Pathogen Survey Network in the northeastern states of India. The council has stated that that this is the beginning of a unique public health initiative in Northeast. Secondly, Sudhir wins para powerlifting gold. So Sudhir has won the para powerlifting gold medal with meet record. He won the gold in the men's heavyweight category, and it is India's first ever para powerlifting gold medal at the Commonwealth Games. Thirdly, ATGM successfully tested. So, indigenously developed laser-guided anti-tank guided missiles were successfully test-fired from main battle tank Arjun by Defense Research and Development Organization and Indian Army at KK ranges with support of Armored Corps Center and School at Ahmednagar in Maharashtra. Fourthly, recommendation for new Chief Justice of India. Rather, it's a very important news for all of us. So, present Chief Justice of India, Justice N.V. Ramanna, has recommended the name of Justice U.U. Lalit to head the judiciary as the new Chief Justice of India. Now, let's see what do we have for legal updates today. Section 313 of the CRPC, that is the Criminal Procedure Code, says that all adverse evidences should be put as equations. Avoid bundling circumstances together with only single opportunity to explain, says the Supreme Court. So the Supreme Court held that while examining an accused under Section 313 of the CRPC, adverse evidence ought to be put forward as questions such as the accused can give an explanation in his defense. This was held in the case of Prakash Tiwari versus State of Madhya Pradesh. Secondly, Punjab and Haryana High Court allows daily wagers plea against closing of evidence to prevent irreparable injury. The High Court has held that the litigants who were daily wage earners would have to be allowed to lead their evidences, and failing to do so would cause irreparable damage, loss and injury. This was held in the case of Satpal versus Divisional Forest Officer, Sonepat Division, Sonepat. This was all for today. We hope you liked the session. If you did, you may like it. Also, if you wish to download the PDF of today's slides, you can join our Telegram channel. The link to our channel is there in the description box below, or you can also simply scan this QR code that you can see on your screens right now. Thank you so much.